Right, so Cardinal Pell was, as we all know, prosecuted, and indeed it was a retrial, which we found out about later. And in that retrial, the victim of the sexual activity that was alleged against Cardinal Pell, which was found by the jury to have taken place, didn't give evidence again. They gave evidence the first time, it was pre-recorded, and it was recorded when they gave their evidence, and the law allows on the second occasion to prevent victims having to give their evidence over and over again in the event of appeals or hung juries. So the jury on the second trial looked at the video of the evidence from the first trial. That jury, the second jury, found him guilty. He's lodged an appeal. And one of the grounds that he's seeking to rely on is that the verdict of the jury is unreasonable or cannot be supported having regard to the evidence. So what they're inviting the Court of Appeal to do is to review the evidence, and they'll mount arguments to say, well, look, if you look at all this evidence, that verdict is simply unsustainable. Now, that's a very difficult ground of appeal to succeed on. It's very rare, and the courts of appeal, and the High Court has said this, shouldn't interfere too readily, too quickly with the decisions of juries. It's a jury decision, and the Court of Appeal shouldn't do so, that is, interfere with it, unless there's something about the evidence that causes all of the judges of the Court of Appeal to have a real doubt about the conviction.